The other thing that the defendant needs to do, as I said, is it not only needs to respond to the case in chief, it has to anticipate rebuttal. And this is the greatest difficulty really for a defense attorney, is not being able to speak again after the rebuttal. We don't go prosecution, defense. The prosecution must stop talking and then allow the prosecution to have the last word. And that's the most difficult part of a defendant's case. But what you can do is you can anticipate or blunt or turn aside or neutralize the effect of the prosecution's rebuttal by anticipating what it's going to be. And for example, in the firefighter case, the defendant could say something like, "Ladies and gentlemen of the jury, now the prosecutor may claim that there was no time to stop, but don't believe it. There was plenty of time. Just look at the evidence." So in other words, he might anticipate that's something that the prosecution would bring up on rebuttal. And you also need to, it's also effective sometimes or many times for the defendant to explain to the jury how this all works. And so, for example, you could say, "Ladies and gentlemen," as the defense attorney, "when I'm done talking to you, I'm going to have to stop speaking, and the prosecution, under the rules, is going to have the last word. But you know that I have answers for what the prosecution will be pointing out." So you might want to make a point of that if you're taking the defense in the mock trial. You might want to make a point of the fact that you can't speak again, and that way the jury can watch for the signs or the things that you're pointing out to them. Now as far as prosecution rebuttal, that's the third and final stage of how the closing argument is laid out, and it's a powerful tool. There's no doubt about it. It's a powerful tool for the prosecution. One of the reasons why the prosecution gets the last word in a criminal case is that they have a very, very high burden. They must prove beyond a reasonable doubt, a very high standard of proof. And so, in fairness to the prosecution, they get the last word. But it can be a knockout punch. Again, it's like Muhammad Ali. It can really be the knockout punch to put the case away, to decide it on rebuttal argument. The defendant has to just stand there quietly, silently, mute, and while the prosecution is speaking. Let me make a comment here. This is a good place to make a comment about the use of notes or reading an opening statement, or excuse me, a closing argument. I would suggest that you are much more powerful in your presentation if you speak extemporaneously, particularly the prosecution on rebuttal. In fact, it has to be extemporaneous because you may not anticipate what arguments the defendant is going to bring up. And but there is also something to say for a man or a woman, an attorney, standing before a jury without notes and presenting the case. Even if the language is stumbling, even if you make mistakes, even if it's halting, there is something much, much more powerful about an extemporaneous presentation as opposed to standing up, finding a piece of paper and saying, "Ladies and gentlemen of the jury, I will now present my closing argument." The defendant has been charged. It just doesn't work. Once you start reading from a piece of paper, the audience is just going to shut you off. It's all over. The audience, you've lost the audience once you start reading. But even with improper grammar, with pauses, with halting voice, whatever it is, you're going to be much more effective if you go for it without notes, in especially the prosecution in your rebuttal argument. Organize your. One thing the prosecution can do, even though he or she does not have an outline to go by, has to kind of fly by the seat of his or her pants. What you can do is return to your theory and your theme. That's why one of the reasons why the theory and the theme are so important. It is it's a foundation that you can come back to over and over again, and the jury can hear it over and over, and you can always return to your theory and theme, and you will come across powerfully and effectively to the jury by responding to your or relying upon your theory and your theme. You can make on rebuttal, you can make constructive criticisms or responses to what the defense has brought out on presenting his or her argument, but you want to be positive. You don't want to just have your rebuttal descend into sort of a defensive position. You want to be positive about your case. You want to respond to concerns, but you want to be positive about your case. Some prosecutors or plaintiffs like to save a single devastating punch or blow for part 3, for the rebuttal period. Remember that technically the rebuttal is limited to issues that are raised by the defendant. So in other words, technically the prosecutor should only address what the defendant raised. But if a defendant does not raise an issue, then the court may possibly still allow additional information or arguments to be brought out on rebuttal. But it is effective if you have something really powerful to say for the end. That's the time to use it, because then you can surprise the defendant.